Good morning, ladies and gentlemen. I'd like to welcome you to County Court Law Number 2. My name is Judge Terrence Holmes. I'm the presiding judge here this morning. This morning, we have what is called an arraignment docket. And what the arraignment is, it's an opportunity for the court to tell you what you've been charged with, what your rights are, and what your options are concerning your case. The case that you have in this court is a criminal case. Criminal cases are divided into felonies or misdemeanors. Your felony cases are referred to as your more serious type offenses, whereas your misdemeanor cases are referred to as petty offenses. Does not mean that they're not serious. It just means that they're not as serious as a felony offense. We handle misdemeanor cases in this court. If you had a felony case, the felonies are divided into 5 categories, and we'll start at the top and work our way on down to the bottom. You have the capital murder, first-degree felony, second-degree felony, third-degree felony, and state jail felony. If a person is convicted of a state jail felony, the range of punishment is minimum 6 months to a maximum of 2 years in the state jail. If a person is convicted of a third-degree felony, the range of punishment is minimum 2 years to a maximum of 10 years in the state penitentiary, and a fine that does not exceed $10,000. And for the state jail, there's a fine also that does not exceed $10,000. Now, if a person is convicted of a second-degree felony, the range of punishment is minimum 2 years to a maximum of 20 years in the state penitentiary, and a fine of that does not exceed $10,000. If a person is convicted of a first-degree felony, the range of punishment is minimum 5 years to a maximum of 99 years to life, and a fine that does not exceed $10,000. Now, if a person is convicted of a capital murder, the range of punishment is life in the state penitentiary without the possibility of parole or death by lethal injection. Now, you don't have to worry about those type punishment because, as I mentioned earlier, your case is a misdemeanor case. And misdemeanors are divided into 3 categories. And we'll start at the top and work our way on down to the bottom. You have the Class A misdemeanor, the Class B misdemeanor, and the Class C misdemeanor. If a person is convicted of a Class C misdemeanor, the range of punishment is fine only. You only could be given a fine up to $500. Now, Class C misdemeanor cases are handled in the Justice Court or JP Court or the Municipal Court, which is the City Court. They come to this court when a person is convicted in one of those courts, and then they file what is called an appeal. And the case comes here, they get a whole new trial. And if you're convicted of the Class C misdemeanor, the range of punishment is the same. It's still fine only, and the fine cannot exceed $500. Now, you cannot get any jail time. However, if you fail to pay the fine, or if your fine is converted to community service and you fail to perform the community service, then the court can issue what is called a capious pro fine, which means that they can issue a warrant for your arrest to either pay the fine or sit the fine out in jail. And if a person has a fine and they have to sit it out, it's $100 per day. Every day that they sit in jail is $100 a day. So, for example, if they had a fine and court costs of $500, that's 5 days that they would have to sit out if they failed to pay the fine and court costs on a Class C misdemeanor. Now, the Class B misdemeanor, the range of punishment is minimum 0 days to a maximum of 180 days in the county jail, or a fine from $0 to $2,000, or you could be given both such fine and confinement. If a person is convicted of a Class A misdemeanor, the range of punishment is 0 days to a maximum of 365 days, which is a year, in the county jail, or a fine from $0 to $4,000, or you could be given both such fine and confinement. Now, You may be eligible for probation. There are two types of probation. One type of probation is adjudicated probation. Adjudicated probation. The other type of probation is unadjudicated probation. Unadjudicated probation. Now, adjudicated probation, we normally refer to it as your regular probation. With the regular probation or the adjudicated probation, you will have a conviction on your record. However, there's something that is called judicial clemency, whereby the court can set aside that conviction and you will no longer have a conviction on your record. And the way it works, or in order to be eligible, you have to, one, successfully complete the probation. Two, there cannot be any more time left on the probation. And three, the probation, you have to be successfully discharged from the probation. If those three things happen, the court has the discretion to grant you judicial clemency. And if he grants you judicial clemency, you will no longer have this conviction on your record. However, if you get a subsequent offense, or if you get another offense later on, then this case that you got or that you received judicial clemency on can be brought back up and it can be used against you. And if you try, it could be brought back up, it could be resurrected, revived, and used against you. Now, if you try to get a license with CPS, then CPS can either deny giving you a license, or if you have a license, they can revoke or suspend that license. Now, the other type of probation is called unadjudicated probation. We normally refer to it as deferred adjudication, unadjudicated probation. With that type of probation, you don't have a conviction on your record. And if you successfully complete the probation, you may be eligible for what is called a non-disclosure. A non-disclosure basically means your record is sealed. We cannot disclose the fact that you were on the deferred adjudication to the general public. Now, as a defendant in a criminal case, you have rights. One of the rights that you have, we're going to talk about it, is your right to have an attorney. The clipboard that have been handed out, everyone who's here should have a clipboard. The first page on that clipboard, it should say, Judge's explanation of rights of the defendants without attorney. On that page, it says that as a defendant in a criminal case, you have three options. Number one, you may hire an attorney. Number two, if you do not have enough money to hire an attorney, you may request that an attorney be appointed to you by the court. And number three, you may represent yourself. Now, in order to represent yourself, that means that you are waiving or giving up your right to have an attorney to represent you and you desire to represent yourself. Now, that document further states that if you want an attorney to represent you and you have enough money to hire an attorney, the case will be reset to give you time to hire an attorney. Reset means that you'll be given another court date to give you time to hire your attorney. If you want an attorney and you do not have enough money to hire an attorney, you would have to fill out a financial questionnaire. The financial questionnaire is the document on that clipboard that is titled Jefferson County Affidavit of Indigence. You would have to fill out the first page of that document and half of the second page. And then once you fill out that form, then the court will see whether or not you meet the eligibility requirements for the appointment of a court-appointed attorney. Now, if you want to waive your right to an attorney or give up your right to an attorney, you will have the option to talk to the prosecutors. The prosecutors are assistant criminal district attorneys who works for the Jefferson County District Attorney's Office. They'll be here in court. You'll be able to talk to them to see whether or not you can settle your case. Now, you may not speak to the prosecutor about your case unless you first sign a written waiver of your right to be represented by an attorney. And the written waiver is the second document on that clipboard. It should be titled Waiver of Counsel for Purposes of Entering a Guilty Plea or Proceeding to Trial. You would have to read and sign that document. I'm going to go over that document with you in about a minute or two. Now, be aware that there are dangers to self-representation. Waiving your right to an attorney and representing yourself may result in a worse outcome for you and your case, including the loss of significant rights and opportunities relating to military service, possession of a firearm, housing and public benefits, child custody, immigration status for non-citizens, and employment. Now, if you choose to represent yourself, you may change your mind at any time and then request that an attorney be appointed to represent you. At the bottom of that document, in bold letters, it states, defendant's choice, mark initials next to only one choice. If your choice is to hire your own attorney, then you will place your initials on the first line to the left. If you have already hired an attorney to represent you, then you'll place your initials on the second line to the left and the name of the attorney on the line to the right. If you want a court-appointed attorney, then you will place your initials on the third line to the left. If you've already been appointed an attorney to represent you, then you will place your initials on the fourth line to the left and the name of the attorney on the line to the right. If you want to waive your right to an attorney, which means if you want to give up your right to an attorney and you desire to represent yourself, then you will place your initials on the fifth line to the left. Once you have finished initialing one of the 5 lines, then you will sign your name on the line that is titled defendant, and you will date it today's date, March 12th of 2024. Now, for those of you who will be waiving your right to an attorney representing yourself, you would have to read and sign the next document that is titled Waiver of Counsel for Purposes of Entering a Guilty Plea or Proceeding to Trial. And I'm going to go over this document with you. And it reads as follows. I have been advised of the nature and charges against me and the dangers and disadvantages of self-representation. My waiver is voluntarily. Voluntarily means that you're doing it of your own free will. Nobody is forcing you to do this. And it is intelligently made, meaning that you know what you're doing. So you're doing it of your own free will and you know what you're doing. So when you say that my waiver is voluntarily intelligently made, furthermore, I have been advised this 12th day of March of 2024 by County Court at Law number 2 of my right to representation by counsel in the case pending against me. I have been further advised that if I'm unable to afford counsel, and one will be appointed for me free of charge, understanding my right to have counsel appointed to me free of charge if I'm not financially able to employ counsel, I wish to waive that right and request the court to proceed with my case without an attorney being appointed for me. I hereby waive my right to counsel, and if that is your choice, then you will sign your name on the line that is titled defendant, and you will date it today's date, March 12th, 2024. Now, as a defendant in a criminal case, you have other rights. Another right that you have is your right to have a trial by jury. Where Chris is sitting in that area, we call that the jury box. 6 citizens from Jefferson County will be selected as jurors on your case. They will listen to all of the evidence. They will listen to the arguments from the attorneys. They will retire to deliberate. And then after they deliberate, they will either find you not guilty or guilty. You also have a right to waive your right to have a trial by jury, which means you have a right to give up your right to have a trial by jury. And by doing so, if you waive your right to have a trial by jury, then your case will come before the judge in one of 3 ways. one way it can come before the judge is by way of a trial. It's called a bench trial. It's a trial without a jury. It's a trial by judge only. The judge will listen to the evidence. The judge will listen to the arguments, and the judge will decide to find you either not guilty or guilty. Another way that your case will come before the judge is by way of an unagreed plea bargain. Now, what a plea bargain is, it's an agreement that you and the state have worked out to settle your case. We call that an agreed plea bargain. If you're unable to come to a plea bargain agreement and you want your case to come before the judge, we call that an unagreed plea bargain agreement. And so on an unagreed plea bargain agreement, it comes before the judge, and the judge will set the punishment. The reason why the judge will set the punishment because on a plea bargain, you're entering a plea of either guilty, which means that you're telling the court that you committed the offense that you've been charged with, or you entering a plea of no contest, which means that you will not be fighting the charges or you will not be contesting the charges. And so therefore, you want the judge to set the punishment, and then the judge with an unagreed plea bargain agreement will set the punishment. Now, the other way that your case can come before the judge is by way of an agreed plea bargain agreement. That means you and the state, you and the district attorney, assistant district attorney, or prosecutor have come to an agreement to settle your case. Then that case will come before the court by way of an agreed plea bargain agreement. The judge can do one of two things. The judge can accept the plea bargain agreement or reject the plea bargain agreement. If the judge rejects your plea bargain agreement, then you have the option or you have the right to withdraw, which means to take back your plea, in essence. For example, let's say you and the state have worked out a plea bargain agreement for you to serve deferred probation. And it comes before the court, and the court said, well, I'm not going to follow that. I'm going to reject that offer. Well, you say, well, judge, since you're not accepting the plea bargain agreement, I take back my plea. In essence, I'm not pleading guilty, and I'm not pleading no contest. You have a right to withdraw. Now, if the judge does follow the plea bargain agreement or accepts the plea bargain agreement, and you decide within 30 days that you would like to appeal your case because you believe that one, you've been wrongfully convicted, or two, the court committed an error by convicting you. If that happens, then you have to get permission from the court or the judge to appeal your case. And if the judge gives you permission, then your case will leave this court and it will go to the Ninth Court of Appeals, which is located right above us on the 3rd floor. They will review your case. They could either grant or deny your appeal. If they grant your appeal, they can either find you not guilty, or they can send the case back down to this court and order this court to give you a whole new trial. If they deny your appeal, then you can appeal it to another court. You can appeal it to a higher court than the Ninth Court of Appeals. You can appeal it to the highest criminal court in the state of Texas, which is the Texas Court of Criminal Appeals, located in Austin, Texas. Now, you would have to file what is called a pro se petition for discretionary review. What that means is this. Pro se means that you are representing yourself. You're by yourself. You don't have a lawyer representing. So you're going to file a petition for them to review your case to see, one, whether or not your appeal should have been granted, or two, whether or not you've been wrongfully convicted, or whether or not this court committed an error by convicting you. Now, they can do one of two things. They can either grant or deny your pro se petition. If they deny your pro se petition, well, if they grant your pro se petition, they can simply find you not guilty, or if they And if they find you not guilty, your case is over. Or they can send it back to the Ninth Court of Appeals with an order for them to do some things, or they can send it back to this court, order this court to give you a whole new trial. Now, if they deny your pro se petition for discretionary review, then at that point, your conviction will stand. Now, as a defendant in a criminal case, you not only have a right to have an attorney and a right to have a trial by jury, right to have a bench trial, do a plea bargain, or a unagreed plea bargain. You also have a right to have witnesses to come to court to testify in your case. Witnesses will sit in that chair that has the microphone in front of it. And what witnesses will do, they can either testify for you or against you. And and you have a right to ask them questions if you're representing yourself, or your attorney has a right to ask them questions. And we call that either direct examination or cross-examination. You also have a right to waive or give up your right to have an attorney. And what that basically means is that you will not be having, waive or give up the right to have witnesses. And what that means is you will not be calling witnesses. It does not mean that the state will not be calling witnesses, because the state of Texas will be calling witnesses in the case that they have against you. You also have a Fifth Amendment right against self-incrimination. What that means is you have a right not to testify in your case. The district attorney, the state of Texas, the government cannot force you to take the witness stand and testify against yourself in your case. If you invoke or you exercise your Fifth Amendment right against self-incrimination. Now, you can waive or give up your right against self-incrimination, and by doing so, you will be testifying in your case that they have against you. Now, the other right that you have a right to have what is called discovery. Discovery means that you have a right to have access or see the evidence that the state will be using against you in your case. You have a right to see witness statements, your statements, police reports, lab reports. You have a right to see video recordings, listen to audio recordings. You have a right to see any type of instruments that they may have or any other type of documents. You have a right to have access to that. Now, you also have a right to waive or give up your right to have discovery. Now, everyone that's here for arraignment, you're here because you have been arrested and you're out of court on bond. You're either out on a cash bond, which means that you pay the full amount of the cash to get out of jail, or you're out of jail on a surety bond, which means that you paid a bondsman a percentage of the bond to get out of jail, or you are out of jail on what we call a PR or a personal recognizance bond, which means you did not have to pay any money to get out of jail. You were just simply released under your own personal recognizance with a promise to appear here today. Now, every day that you spent in jail, whether it be 1 minute, if it was 1 minute, that's considered a day. Okay. So every day that you spent in jail can be used as credit towards your punishment. So, for example, let's say you spent 5 days in jail. You and the state has come to an agreement for you to serve 5 days in jail. What that basically means, you won't have to serve any more time in jail because you've already served 5 days in jail. Therefore, you'll be given credit for the time that you have already served. Now, if the state is offering you 7 days in jail and you serve 5 days in jail, that means you will have to only serve 2 more days in jail because you are given credit for the 5 that you've already served. Now, every day that you spent in jail can also be used as credit toward your fine and court costs. So if you spent 5 days in jail, now every day in jail is $100 per day. So if you spend 5 days in jail, that's $500 that can go towards your fine and court costs. So if the state is offering you fine and court costs of $500, you won't have to pay anything. Why? Because the time that you spent in jail has already paid it off. Now, if they're offering 7 days in jail, then, if they're offering you a fine and court cost of $700, that means you would only have to pay $200 because you already have $500 because of the 5 days that you spent in jail. Now, you're required to pay the $200 on the day that you enter the plea in your case. If you cannot pay the $200, then we can put you on what is called a payment plan, which means that you can pay so much per month until it's paid off. Now, some people may not have the ability to pay off the $200. No problem. Because at that point, then we can convert it to what is called community service. You will receive $12.50 for every 1 hour of community service that you perform at a nonprofit organization. So if you work 8 hours, that's $100 that will go toward your fine and court costs. So in this scenario, with your order to pay $200, you can't pay it, it's converted to fine and court costs. You work 2 days, 8 hours, 2 8-hour days, that's $200 that will go toward paying the balance off for your fine and court costs. Okay. Now, Jefferson County has a program for people who have not been in trouble before. If this is your first time being in trouble, well, Jefferson County has a program that is called pretrial diversion. With that program, they will dismiss your case and you can get it wiped off of your criminal record. Now, the way it works, you have to have an attorney to help you to get into the program. And 2, it cannot be an offense involving resisting arrest or unlawfully carrying a weapon. And 3, it has to be your first time getting into trouble. Now, if that's the case, you get into the program, they dismiss the case, you complete the program, then you can get it expunged, which means wiped off, erased, or deleted from your criminal record. It's just like it never happened. Okay? Now, if you are a veteran of any one of the military branches, Jefferson County also has a program that is called Veterans Court. And with the Veterans Court program, that is also part of the pretrial diversion program. You just have to be a veteran. That's the only requirement. And with that program, what they will do, if you get into the program, you complete the program, and then you can get the case, you can get what is called a non-disclosure. Your record is sealed, basically. And so it's a seal to the general public. So the general public cannot have access, but the government can. Okay. And there's a list of agencies that can have access to that. So if you're a veteran, if you're interested in that Veterans Court program, just let us know. And we can give you the paperwork so that you can get into apply for that program. Now, this court, County Court at Law number 2, has a program that is called the CSI program. The CSI program stands for Community Safety Initiative. That's a program that I started within the first 100 days of taking office. So in my first 100 days of being elected, taking office, I started this program that is called the CSI program. The program was started in March of 2017. With that program, the program is designed to address the issue of what we call recidivism. Recidivism is basically means people commit crimes over and over. And so how do we stop that? Or how do we prevent that? Well, we have the CSI program. The CSI program is designed to make Jefferson County a safer place for all of us to live, work, go to school, raise our children, go to church. And the way the program works, we have partnership with agencies in our local community. One of the agencies that we have a partnership with is the Spindletop Center. Spindletop is our local mental health or our regional mental health center because it's the mental health center for Southeast Texas. With that program that Spindletop has, Spindletop, and then we have Chris and Deputy Hinton who's going to come here in a few minutes and tell you more about the program. But basically, what the program entails is they will do a private interview with you. And then they can do an assessment, develop a treatment plan, either outpatient or inpatient, to address your mental health needs. Now, You don't have to be insane or incompetent to participate in the program. You can merely suffer from anxiety or depression. And with that program, they have the ability to address your mental health needs. The other thing is, Spindletop also has a program that is called ATAR. ATAR stands for Addiction Treatment and Recovery. Along with that Spindletop program, we have a partnership with our local drug and alcohol council that has a program that is called OZAR. OZAR stands for Outreach, Screening, Assessment, and Referral. With those programs, it's for individuals who might have issues with drugs or alcohol. And with that program, they can address your drug and alcohol issues. They can do a screening, an assessment, and a referral for either outpatient or inpatient treatment, depending on what your drug and alcohol needs are. The other program that we have is we have a partnership with the Golden Triangle Empowerment Center that has a partnership with Lamar University. Lamar University has a program that is called CICE. CICE stands for Center for Innovation, Commercialization, and Entrepreneurship. It is a job training program and a job placement program in the hotel industry, the shipping industry, or the chemical industry. If you're looking for a better job, you get trained in any one of those areas, they will help you to get a job in the area that you're trained in. Also, if you haven't graduated from high school, you'd like to get your GED, CICE also has a GED program, Graduate Equivalency Diploma, that you can receive. Now, all of these programs that I just mentioned are free. They do not cost you anything. Only thing it does cost you is time. And I like to say in this quote, we do not just give time, we take our time. And that simply means we do not just arrest the problem, we address the problem. And we believe that if we address the problem, we can produce productive people. And if we produce productive people will not commit crimes. Why? Because they have too much to lose. And so I say this, when you come to county court at law number 2, we do not just have court as usual, we have unusual court. And it's not because we're different, but it's because we're trying to make a difference in the lives of the individuals that comes before this court. And if we make a difference in their life, we will make a difference in their home. And if we make a difference in their home, we will make a difference in the community, because what comes out of the home goes into the community. So if you're interested in any one of these programs, just let us know. And we have some brochures with the information, phone numbers, and contact information that you would need to get into these programs. And the other beauty about the program is this. All of these programs that I just mentioned can be used as community service. So for example, let's say you were ordered to pay fine and court costs. You could not pay the fine and court costs, and so they converted to community service. And let's say you're in, say, drug treatment or mental health treatment, or you're getting while you're in GED class, or you're in a class to learn how to do a job. Okay? Every 1 hour that you're in class or in treatment, guess what? That will go toward community service. $12.50 will go toward your fine and court costs. So I tell people this all the time. It's like you doing one thing, but you're getting credit for 3. It's like killing 3 birds with 1 stone. You're in the program, community service, and you're paying your fine and court costs, all by taking care of an issue that you may have, whether it's drugs, alcohol, whether it's mental health issues, whether it's not having employment, or if you're looking for a better job, or whether or not you want to improve your education. So if you're interested in that, any one of these programs, just let us know. We have the brochures that we can give you to get you started on the right track to becoming a productive person. Now, at this time, we have Deputy Hinton and Chris. They're going to come to you and tell you more about the program that Spindletop has to offer. Deputy Hinton and Chris.
Thank you, Your Honor.
You're welcome.
Good morning. My name is Steve Hinton. I'm a mental health deputy licensed by the state commission here with the sheriff's office. This is my coworker here, Chris. Now, Chris is a qualified mental health professional with Spinal Tap. The reason we are both here this morning in this courtroom is because the judge cares about every single person who comes to again. What the judge has found, what statistics prove, is those who have legal issues commonly have mental health needs, such as use disorder, or sometimes just a lack of community resources to help you with a particular situation.
I know the judge mentioned empathy and depression, and a lot of times that's what you see. It's one of those things where everyone deals with it at some point, and being involved in the court process does not necessarily make it easier. I know the judge mentioned outpatient resources. We can get you information on inpatient resources, but we can help you with outpatient resources if you need it. It's one of those things where there's a lot of really great resources in our area that are well funded, and not just our area, but Texas in general. They're well funded, but they're not well advertised, and sometimes even just finding them can feel a bit like jumping through hoops. And that's kind of where we come in.
Maybe this is your first time to be in court, maybe it's your 10th time to be in court, there's still hope. In fact, what we're offering you today has the ability to change your life, but we're gonna need something from you. We're gonna need you to share that need with us so we can best figure out how to advocate for you and help you. And Chris is gonna explain how you can share that need with us in a very private way.
So whenever you guys came in, we handed out a form to everybody. On that form, you'll see a little red area up top. That is built in so that it is a baseline HIPAA consent form. The reason it's built that way is so that you know that any information you put on that form is protected under state law the same way your medical information is. It will not be shared with anybody else. It will not be seen by anybody other than the only person to contact you will be me. And whenever the judge talks about an interview, it can just be a conversation. It's just, how are you doing? What do you want to talk about? What do you need help with? The only thing you're agreeing to on that form, though, is me contacting you once in a manner of your choosing. If you choose to speak privately, you can have to go to the back and talk, or if the court moves fast and you have something you have to do, because they're not going to interrupt any of y'all's time or the court's time, we can always set up a time to talk later. The big thing is, though, is getting you guys contact information and making sure that you have access to the resources when you need them, and that you have numbers to reach out to should you ever find yourself in a situation where you want to talk, or if you need information from someone else that you care about. That's the beauty of this, that the judge lets us be a loophole, and that's what we are. It doesn't matter if you're here for yourself. It doesn't matter if you're here to support. It doesn't matter if the information you're trying to find is for someone that you care about. The important thing is that we use the moment, because we know there's people that don't show up, right? You guys all did. You're all here. We know you work hard for yourself. We know you take this seriously, and if we can make it easier, that's the only thing we want to do.
Also have this Spindle Top card I'm going to give it to everybody before you leave here today. It has a 1-800 number on there. If you ever find yourself in an unsafe place, you can call that number and get help immediately.
Usually you do have brochures, we're sorry to throw those right now. On the bottom of your sheet, you'll also see, office numbers as well. So those go straight to Spindle Top. You can ask to talk to the court personnel if you want to get in contact with you soon. You can get in contact with you guys the next day. Now, on that, like you said, that 1-800 number, it is active almost statewide, because we also recognize that people come to court in Jefferson County that are not anywhere close to here, right? It's one of those things where it just happens. It doesn't matter if you're from Louisiana or the other side of Texas. If you have something you need, we can try and help find it. That number is active almost statewide. I say almost because, as we all know, there are plenty of dead areas in Texas. But you can call it 24/7. That is a crisis number. If you are, say, 6 a.m. Christmas morning, you need to talk to somebody, they will pick up. They'll be there. If it's outside of the crisis time, we want to make sure that you guys get our numbers too, so that you can reach out if you need anything.
Just shortly, the court's going to go into recess. When it does, we'll come out there, we'll visit with you, we'll pick up those documents from you, and I'll be handing this out to you.
Also, if you have any questions, we'll be able to answer them then. We look forward to working with you.
Thank you for your time. Thank you, Your Honor.
Okay, you're welcome, Deputy Hinton, Chris. Now, ladies and gentlemen, we're gonna go into recess in a few minutes. That paperwork that you have on your tablets, if you need any help with that paperwork, we have our court personnel who's here, who is ready and able to help with completing the paperwork that you need to fill out. Once the paperwork is filled out, Then our core personnel will pick up that paperwork. We're going to go through it, and then we're going to call you up before the bench, one at a time. And then we're either gonna put you in the category of wanting to hire an attorney, whether or not you want a court-appointed attorney, or whether or not you want to represent, waive your right to attorney, represent yourself. Now, this is gonna take a little time to do. If you need to use the restroom, there are restrooms right outside of the courtroom. The men's restroom is right in front of County Court at Law Number 3, which is next door. And the women's restroom is on the opposite side of the hall in front of the 172nd District Court. Now, do not leave the courthouse. If you leave the courthouse and your name is called and you do not answer, then a warrant can be issued for your arrest. You'll be arrested and placed in the Jefferson County Jail. Okay, your bond will be forfeited. All right. So at this time, if you need any help with your paperwork, just raise your hand, and our core personnel who's here can help you with your paperwork. So at this time, the court will be in recess. Jefferson County Court at Law number 2 is back in session. Court is in session with the arraignment docket. First case is cause number 23 CCCR 2542. Case is styled the state of Texas versus Charles Adams. Mr. Adams, would you please come forward? Mr. Adams, your full name is Charles Adams?
Yes, sir.
Mr. Adams, would you please raise your right hand? The other hand. Mr. Adams, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth so help you God? Mr. Adams, you may put your hand down. How are you doing, Mr. Adams? That's good. Mr. Adams, I have before me a document that is titled Judge's Explanation of Rights to Defendants Without Attorney. Do you recognize this document?
Yes, sir.
Is this your signature on the line that's titled Defendant?
Yes, sir.
Are these your initials on the line that state you want to reset this case to hire an attorney?
Yes, sir.
Mr. Adams, before you signed and initialed this document. What's the?
She made it. We already had the.
Oh, okay. Give me that clipboard. I need a clipboard with a pen.
Told us to check that, even though it.
Oh,
She made it, this is.
okay, well, he said he hired her. That's-
He's on vacation right now.
I know. We might need to find out if the court dates that they have over there, so we'll have it on that court date, because I'm sure she's gonna get the letter. Now, Mr. Adams, I have before me a document that is titled Judge's Explanation of Rights to Defendants Without Attorney. You recognize this document? And is this your signature on the line that's titled Defendant?
Yes, sir.
Are these your initials on the lines that said I've hired an attorney whose name is? She spelled it wrong. Brittany Holmes. Is that correct?
Yes, sir.
And now, before you signed and initialed this document, did you read the document? And did you understand what you read? And is everything in this document true and correct to the best of your knowledge?
Yes, sir.
Okay, so Mr. Adams, your case is gonna be reset, but you probably won't be back in this court again because your case is gonna be transferred to County Court at Law number 3 because Brittany Holmes is my daughter and there's a conflict of interest. Okay? And so we need to, this case is gonna be transferred. So put it on a date that they have their cases over there. All right. All right. You're gonna stand in front of the court coordinator right here. Just get your reset. Once you get your reset, you're free to go and you have a blessed day. Okay. Just, yeah, stay in contact with your attorney and your bond. They'll be getting your court, your reset dates. Next case is cause number 23 Aura 2461, case of style of the state of Texas versus Yeshunio Ray Berry. Mr. Berry, your full name is Yeshunio Ray Berry.
Yes, sir.
Mr. Berry, would you please raise your right hand? Mr. Berry, do you swear firm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Mr. Berry, you may put your hand down. How are you doing, Mr. Berry?
I'm doing all right. How you doing?
I'm doing fine, thanks for asking. Mr. Berry, let's see. I have before me a document that is titled Judge's Explanation of Rights to Defend Us Without Attorney. You recognize this document?
Yes, sir.
And is this your signature on the line that's titled Defender?
Yes, sir.
Are these your initials on the line that state that you have hired an attorney? His name is Ralph Kimmler?
Yes, sir.
Okay. Before you signed and initialed this document, did you read the document?
Yes.
Did you understand what you read?
Yes, sir.
And is everything in this document true and correct to the best of your knowledge?
Yes, sir.
Okay. Mr. Berry, I read your answers. Your case is going to be reset. Your attorney, Mr. Ralph Kimmler, has to get this court a letter of representation. And I'm sure once he does that, the case is going to be reset to maybe reset to a different day. But in the meantime, stay in contact with your attorney and your bondsman. Stand in front of our court coordinator. Once you get your reset, you're free to go and you have a blessed day.
All right.
Next case is called number 23CCCR 228880. Case of style of state of Texas versus Eric Valdez. So Valdez, would you please come forward? Mr. Valdez, your full name is Eric Valdez.
Yes, sir.
How are you doing, Mr. Valdez?
All right.
That's good, Mr. Valdez. Would you please raise your right hand? Mr. Valdez, do you swear affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? Mr. Valdez, you may put your hand down. Mr. Valdez, I have before me a document that is titled Judge's Explanation of Rights to Defend Us Without Attorney. Do you recognize this document?
Mm-hmm.
Is this your signature on the line that's titled Defendant? Are these your initials on the line that state you'd like to have your case reset to hire your own attorney?
Yes.
Mr. Valdez, before you signed and initialed this document, did you read the document? Did you understand what you read? And is everything in this document true and correct to the best of your knowledge? Okay, Mr. Valdez, your case is going to be reset to give you an opportunity to hire your attorney. Please have a seat in that first chair, and then when she's finished with this gentleman, you go up to the window. She's gonna give you a reset. Once you get the reset, you're free to go and you have a blessed day. You're welcome. Asa Jones. Mr. Jones, you could give him that pen all right. Now, Mr. Jones, your full name is Asa Jones. Would you please raise your right hand? Do you swear affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
You may put your hand down. How are you doing, Mr. Jones? You good? That's good. Now, Mr. Jones, I have before me a document that is titled Judge's Explanation of Rights to Defend Us Without Attorney. You recognize this document? And is this your signature on the line that's titled Defendant? Or these your initials on the line that state you want your case reset to hire your own attorney?
Yes, sir.
Now, Mr. Jones, before you sign and initial this document, did you read the document? Did you understand what you read? And is everything in this document true and correct to the best of your knowledge? Okay. Mr. Jones, your case is going to be reset to give you an opportunity to hire an attorney. But before your case is reset, bondsman is going to give you, the bailiff is going to give you some bond conditions. I'm going to go over these bond conditions with you. The document that has just been handed to you is titled Standard Bond Conditions in County Court at Law Number 2. Do you see that title? Okay, and it reads as follows. Following the return of a criminal information in County Court at Law Number 2 of Jefferson County, Texas, all bail bonds executed for release of any defendant named herein are ordered subject to the additional conditions. Number 1, the defendant shall commit no offense against the laws of this state, any other state, or of the United States. Do you understand that condition? Condition number 2, the defendant shall submit to testing for drugs and alcohol at any time as directed by the court the court may revoke the bond and order the arrest of any defendant who A, refuses to submit to a test for drugs and alcohol when directed to do so by the court, or B, submit to a test for drugs and alcohol, and the test indicates the presence of drugs and alcohol in the defendant's body. Do you understand that condition?
Yes, sir.
Condition number 3 does not apply. And condition number 4 does not apply. However, condition number 5 does apply. And condition number 5 states as follows: defendant is prohibited from possessing a firearm or ammunition unless defendant is a peace officer as defined by section 1.07 of the Texas Penal Code, actively engaged in employment as a sworn, full-time, paid employee of a state, agency, or political subdivision. Do you understand that statement?
Yes, sir.
Okay. Now, Mr. Jones, I noticed that when I got to this section, you smiled or you grinned to yourself. Okay. If you have a gun or any ammunition.
Oh, that's not even what I'm saying.
Okay, well, you smiled on this one. You didn't smile on the other two. Okay. If you possess a gun or a firearm or any ammunition, your bond can be revoked. Your bond is revoked. You may be placed in Jefferson County Jail. You understand that? Now, if you violate any one of these conditions, your bond can be revoked. And you could be placed in the Jefferson County Jail. Do you understand that? Now, Mr. Jones, you've been here before, haven't you? Okay. So your case is going to be reset to give you an opportunity to hire your attorney. And please have a seat in that first chair. Follow the directions of the coordinator. You have a blessed day. Next case is cause number M332968. Case of style of state of Texas versus Max Robert Colbert. Your full name is Max Robert Colbert?
Max Dale Colbert.
Max Dale Colbert?
Yes, sir, that's the area.
Okay.
Definitely.
How are you doing, Mr. Colbert?
Good.
That's good, Mr. Colbert. Would you please raise, that door is locked? Please raise your right hand. Mr. Colbert, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth to help you God?
Yes, sir.
Mr. Colbert, you may put your hand down. Mr. Colbert, I have before me two documents. First document is titled Judge's Explanation of Rights to Defendants Without an Attorney. And this document states this. Do you recognize this document?
Yes, sir.
Is this your signature on the line that's titled defendant?
Yes, sir.
Or are these your initials on the line that state you'd like to apply for court-appointed attorney?
Yes, sir.
Next document is titled Jefferson County Affidavit of Injuries. Do you recognize this document?
Yes, sir.
And on page 2 of this same document, there's a signature above the line that's titled defendant signature. Is this your signature?
Right.
Mr. Colbert, before you sign and initial these documents, did you read the documents? Did you understand what you read? And is everything in these documents true and correct to the best of your knowledge?
Yes, sir.
Mr. Colbert, I read your answers. Based on your answers, you meet the eligibility requirements for the appointment of a court-appointed attorney, and the attorney that will be appointed to represent you is Attorney Langston Adams. Attorney Adams will be given information to contact you, and you will be given information to contact him. Our court coordinator will give you that information. But before she gives you that information, I need to give you some bond conditions. I'm going to go over these bond conditions with you.
Yes, sir.
The title is Standard Bond Conditions in County Court at Law Number 2. Do you see that title?
Yes, sir.
And it reads as follows: following return of criminal information in County Court at Law Number 2 of Jefferson County, Texas, all bail bonds executed for release of any defendant named herein are ordered subject to the additional conditions. Number 1, the defendant shall commit no offense against the laws of this state, any other state, or of the United States. Do you understand that condition?
Yes, sir.
Condition number 2, the defendant shall submit to testing for drugs and alcohol at any time as directed by the court. The court may revoke the bond and order the arrest of any defendant who A, refuses to submit to a test for drugs and alcohol, when directed to do so by the court, or B, submit to a test for drugs and alcohol, and the test indicates the presence of drugs and alcohol in the defendant's body. Do you understand that condition? And condition number 3 states that the defendant shall not communicate either directly or indirectly with the alleged victim of the pending offense. And the defendant shall not go near any residence, school, or other location frequented by the alleged victim. Do you understand that condition? And, okay,
We're separated. I'm trying to be separated.
well, you just have to make sure you do not violate this condition.
I've done my best to stay away from.
Or not try your best, you now don't try your best, you just need to not, you need to obey this rule. If not, there are some consequences.
Yes.
Now, condition number 4 doesn't apply because that only applies in the DWI case. Condition number 5 does apply. Condition number 5 states the defendant is prohibited from possessing a firearm or ammunition unless defendant is a peace officer as defined by section 1.07 Penal Code, actively engaged in employment as a sworn full-time paid employee of a state agency or political subdivision. Do you understand that condition?
Yes, sir.
Now, if you violate any one of these conditions, your bond can be revoked, and if your bond is revoked, a warrant will be issued for your arrest, and you'll be placed in the Jefferson County Jail. Do you understand that? Now, Mr. Culver, your case is going to be reset. You're going to get a reset from our court coordinator. Once you get the reset, you'll be free to go, and you have a blessed day. Please have a seat in that first chair.
Yes, sir.
You're welcome. Next case is cause number 23CCCR2500. Case is style of State of Texas versus Shay Monique Arsenault. Need to put a person. Okay, this is cause number 23CCCR2500. Case is style the State of Texas versus Shay Monique Arsenault. Ms. Arsenault, is that your full name?
Yes, sir.
Ms. Arsenault, would you please raise your right hand? Ms. Arsenault, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Ms. Arsenault, you may put your hand down. How are you doing, Ms. Arsenault?
I'm good, how are you?
I'm doing fine, thanks for asking. Ms. Arsenault, I have before me 2 documents. First document is titled Judge's Explanation of Rights to Defendants without Attorney. Ms. Arsenault, do you recognize this document?
Yes, sir.
Is this your signature on the line that's titled Defendant?
Yes, sir.
Or these your initials on the line that state you'd like to apply for a court-appointed attorney?
Yes, sir.
I also have another document that is titled Jefferson County Affidavit of Injuries. Do you recognize this document?
Yes, sir.
On page 2 of the same document, there is a signature above the line that is titled Defendant Signature. Is this your signature?
Yes, sir.
Ms. Arsenault, before you sign and initial these documents that I just showed you, did you read the documents?
Yes.
Did you understand what you read?
Yes.
And is everything in these documents true and correct to the best of your knowledge? Ms. Arsenault, I read your answers. Based on your answers, you meet the eligibility requirements for the appointment of a court-appointed attorney. The attorney that will be appointed to represent you in this case is Attorney Don Boudreaux. Attorney Don Boudreaux will be given information to contact you. You will be given information to contact him. A court reporter will give you that information. Once she gives you that information, you'll be free to go. You have a blessed day. Please have a seat in that 3rd chair on the wall. She'll give it.
Thank you.
You are. Next case is cause number 23CCCR2368. Case is style of State of Texas versus Nathaniel Clark. Mr. Clark, would you please raise your right hand? Mr. Clark, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Mr. Clark, you may put your hand down. How are you doing, Mr. Clark?
Fine, and you?
I'm doing fine. Thanks for asking. Mr. Clark, I have before me 2 documents. The first document is titled Judge's Explanation of Rights to Defendants without Attorney. You recognize this document?
Yes.
Is this your signature on the line that's titled Defendant?
Yep.
Or are these your initials on the line state you'd like to apply for court-appointed attorney? I also have another document that is titled Jefferson County Affidavit of Injuries. Do you recognize this document? On page 2 of this same document, there's a signature above the line that is titled Defendant Signature. Is this your signature? Mr. Clark, before you sign and initial these documents, did you read the documents?
Yes.
Did you understand what you read? And is everything in these documents true and correct to the best of your knowledge? Okay, Mr. Clark, I've read your answers. Based on your answers, you meet the eligibility requirements for the appointment of a court-appointed attorney. The attorney that will be appointed to represent you in this case is Attorney Tom Burbank. Attorney Burbank will be given information to contact you. You will also be given information to contact him. Our court coordinator is going to give you that information. Once she gives you that information, you'll be free to go and you have a blessed day. Please have a seat in that first chair on the wall.
Thank you.
All right, you're welcome. Next case is cause number 23CCCR 0108. Case is style of state of Texas versus Otis D. Poulard. And his second case is cause number 24CCCR 0719. Mr. Poulard, your full name is Otis D. Poulard. Mr. Poulard, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? Mr. Poulard, you may put your hand down. How are you doing, Mr. Poulard? Not too good? Okay. Hopefully you'll be doing better after you leave here. Now, Mr. Poulard, I have before me a document that is titled Judge's Explanation of Rights to Defendants Without Attorney. Do you recognize this document?
Yes, sir.
Is this your signature on the line that's titled defendant?
Yes, sir.
Are these your initials on the line that state you'd like to apply for court-appointed attorney?
Represent self.
You want to rep?
That's why I had it.
Oh, it was a check mark and initial. We need to get him to
Deal with this.
re-sign that. I need to. Okay, now, Mr. Poulard, have before me a document that is titled Judge's Explanation of Rights to Defendants Without Attorney. Again, is this your signature?
Yes, sir.
And are these your initials on the line that state you want to waive your right to an attorney and represent yourself?
Yes, sir.
Okay, now, before you sign and initial this document, did you read the document?
Yes, sir.
Did you understand what you read?
Yes, sir.
And is everything in this document true and correct to the best of your knowledge?
Yes, sir.
Okay. Mr. Poulard, I've read your answers. Just have a seat, and one of the prosecutors is going to come out and talk to you about your case.
Thank you, Aaron.
Okay? Next case is the next case is cause number 23CCCR 2146. Case of style of state of Texas versus Solomon Johnson. Oh, you know what? He needs to sign a waiver. No, Mr. Poulard, yeah. There should be some up here. It's in that second file, that one, right? No, right in the front. The second one. That's the first one. Like, is that waiver of counsel? Yeah, that's what he needs to fill out. You got a clipboard for him?
Yeah, that's.
Okay, Mr. Johnson, your full name is Solomon Johnson? Mr. Johnson, I have before me two documents. The first document is titled Judge's Explanation of Rights to Defendants Without Attorney. You recognize this document? And is this your signature on the line that's titled defendant?
Yes, sir.
Or these your initials on the line that state you'd like to waive your right to an attorney and represent yourself?
Yes, sir.
I now have another document here that's titled Waiver of Counsel for Purposes of Entering a Guilty Plea. Do you recognize this document?
Yes, sir.
And is this your signature on the line that's titled defendant?
Yes, sir.
Now, Mr. Johnson, before you sign and initial these documents, did you read the documents?
Yes, sir.
Did you understand what you read?
Not gonna say.
You didn't understand the second one? Okay, let me do this here. This document states that I have been advised of the nature and charges against me. Now, you're charged with the offense, Class A misdemeanor offense of unlawfully carrying a weapon. You understand that?
Yes, sir.
And the nature and the charges against me and the dangers and disadvantages of self-representation. Now, in the first document that you said you understood, I read you a paragraph that reads as follows. Be aware that there are dangers to self-representation. Waiving your right to an attorney representing yourself through an attorney may result in a worst outcome for you and your case, including the loss of significant rights and opportunities relating to military service, possession of a firearm, housing and public benefits, child custody, immigration status for non-citizens, and employment. Okay, so that's the dangers and disadvantages of self-representation. Let's see. I have been further advised. Okay, then the next sentence says, my waiver is voluntarily and intelligently made. Voluntarily means that you're doing it of your own free will. Nobody's forcing you to sign this waiver.
Yes,
Intelligently made means that you know what you're doing.
yes,
Okay, so you're doing it of your own free will and you know what you're doing. And it says, furthermore, I have advised this 12th day of March, which is the day of 2024, which is the day's date by the County Court at Law Number 2, which is this court, of my right to representation by counsel. That was on the first document that said you had a right to have an attorney. Your right to have an attorney, you had three options. You can either hire an attorney. If you could not afford to hire an attorney, you may request that an attorney be appointed to represent you. And number three, you may waive your right to an attorney and represent yourself. Okay, so you said that this document says that I have been advised that if I'm unable to afford counsel, one will be appointed to me free of charge. Understanding my right to have counsel appointed for me free of charge if I'm not financially able to employ counsel, I wish to waive that right. Waive that right means I wish to give up that right and request the court to proceed with my case without an attorney being appointed for me. In essence, I want to represent myself.
yes,
I hereby waive my right to an attorney, or I hereby give up my right to an attorney. Do you understand that?
Yeah.
Okay. So now, do you understand everything that's on this document?
yes, sir.
And do you understand everything that's on both of these documents that I just went over with you?
Yes, sir.
Is everything in these documents true and correct
Yes,
to the best of your knowledge? Okay. So Mr. Johnson, just have a seat. One of the prosecutors is going to come out and talk to you in a few minutes. He already have a wait. The other gentleman didn't have it. Did he finish his? I think he did. You can come on back up, Mr. Poular. That goes with this. Okay, Mr. Poular, I have a document that is titled Waiver of Counsel for Purposes of Entering a Guilty Plea or Proceeding to Trial. You recognize this document?
Yes,
And is this your signature on the line that's titled defendant?
yes, sir.
Mr. Poular, before you sign and initial this document, well, before you sign this document, did you read the document?
Yes.
Did you understand what you read?
Yes, sir.
And is everything in this document true and correct to the
Yes,
best of your knowledge? Okay, Mr. Poular, you can have a seat and one of the prosecutors will come out and talk to you about your cases.
Thank you very much.
You're welcome. Okay, the court will be in recess. Okay, now, Mr. Poulard, you rejected the state's offer, and so your case is going to be reset. The court coordinator is going to reset your case. Now, let me tell you this here. When you come back in, I'm gonna have to give you, I know you said you have a medical appointment or something
Yes.
that you have to.
Just emailed it to back short.
No, that's fine. No, what I was getting ready to say is that I'm gonna give you what is called a Faretta warning when you come back, because that takes some time to go through. Okay? And the court coordinator is gonna get you reset. Once you get your reset, oh, yeah. Once you get your reset, you'll be free to go. You have a blessed day.
Thank you.
No, it's not, it doesn't go straight go for the announcement. Because he's gonna have to get with the prosecutors to, for discovery and stuff. Yeah. Yeah, so you'll get with the district attorney's office, set an appointment for the discovery, okay? Okay, you are. It's Otis Poulard. Next case is, cause number 23 CCCR 2146, case of Solid State of Texas versus Solomon Johnson. Okay, Mr. Johnson, you've talked to the state, is that correct?
Yes.
And you have rejected their offer, is that correct?
Yes.
And you want your case set for trial, is that correct?
Yes.
Okay, now, what I need to do is give you what is called a Faretta warning. It's just from the case of Faretta versus California, 422-806, or US 806, 1975. Now, please raise your right hand. Do you swear affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Now, I'm going to ask you the following questions. I need your responses. Have you ever studied law?
Yes.
Have you ever represented yourself in a criminal action? Do you understand the charges against you?
Yes.
And let's see, are you aware of the maximum penalties for your charge?
Yes.
Okay, you're charged with a Class A misdemeanor, and the range of punishment, minimum 0 days, so maximum 365 days in the county jail, fine from $0 to $4,000, or you could be given both such fine and confinement. Do you understand that?
Yes.
All right. Now, are you aware of the exact legal elements of your charge? Okay, the elements for your charge, Mr. Johnson, are located in a document that is called information, or the information sheet that has been filed by the Jefferson County District Attorney's Office. And I'm going to, once I can get it pulled up. Okay. I'll just read to you what the information is. The information that was filed by the Jefferson County Criminal District Attorney's Office states as follows. In the name and by the authority of the state of Texas, comes now the undersigned Assistant Criminal District Attorney of Jefferson County, Texas, on behalf of the state of Texas, presents to the County Court of Law in Jefferson County, Texas. Now, these are the elements that in Jefferson County, Texas, Solomon Johnson, here style of defendant, heretofore on or about August 5th, 2023, did then and there intentionally, knowingly carry on or about his person a handgun while under the age of 21 years old, and the defendant was not on the defendant's own premises or premises under the defendant's control, and the defendant was not inside or directly en route to a motor vehicle that was owned by the defendant under the defendant's control. So those are the elements that the state has to prove beyond a reasonable doubt in order for them to find you guilty. Do you understand that?
Yes, sir.
All right. Now, do you realize that if you're found, do you realize that if you represent yourself, you are on your own, which means as a judge, I cannot tell you how you should try your case or even give you advice as to how to try your case. Do you understand that?
Yes, sir.
And as also as a judge, I cannot help you in any way. Do you understand that?
Yes.
Are you familiar with the Texas rules of evidence and Texas case law? Do you realize that the Texas rules of evidence and Texas case law govern what evidence is admitted? And in representing yourself, you must abide by those rules.
Yes.
For example, how do you conduct a voir dire? Do you know how to conduct a voir dire? How to pick a jury?
Sir.
What are the grounds for excusing a juror for cause? Do you know that?
Yes, sir.
Do you know what is hearsay? And what are some of the exceptions to hearsay? And do you know what is required or proper to impeach a witness? Do you know when is character evidence allowed? Okay. Do you know when and how to make a proper objection? Do you know, let's see, when and how to move for what is called a directed verdict?
Yes.
Do you know how to offer evidence to protect the record for appeal? Do you know the proper grounds for a mistrial? Are you aware that that failure to timely move for a mistrial may waive crucial mistakes made by the state or this court?
Yes, sir.
Okay. Do you know how to request and object to jury instructions? Are you familiar with the Texas rules of criminal procedure? Do you realize that those rules govern the way in which a criminal action is tried in court? Now, Mr. Johnson, I must advise you that, in my opinion, you would be far better defended by a trained lawyer than you can by yourself. I think it is unwise for you to try to represent yourself. You're not familiar with the law. You're not familiar with the court procedures. You're not familiar with the rules of evidence. I would strongly urge you not to try to represent yourself. Now, in light of the penalty that you might suffer if you are found guilty, and in light of all the difficulties of representing yourself, is it still your desire to represent yourself and to give up your right to be represented by an attorney?
Yes, sir.
Okay. Now, in light of all the penalty that you might suffer if you are found guilty, and in light of all the difficulties of representing yourself, is it still your desire to represent yourself and to give up your right to be represented by an attorney? Okay, so at this time you have three options. You can either, one, hire an attorney, see if you qualify for a court, well, two options, see if you qualify for a court-appointed attorney since you no longer wants to waive your right to an attorney. And we can give you that judge's explanation, well, over here, if you can change, I can give you an opportunity to change this document. This is, you already had signed it, but that's Mr. Johnson. So it's either you got options 1, or 3? At the bottom, you got 5 options. You had previously selected 5, which waiving your right to an attorney, but since you changed your mind, it's 1 or 3 at the bottom.
Yes, sir.
Okay. Have you already made your choice? Okay, so he wants to waive his right to an attorney. I mean, you want your case reset to hire an attorney, is that correct? All right. Now, we're going to give you an opportunity to also need to give you some bond conditions. This is, I don't know, for carrying a weapon case. The bailiff is gonna give you these bond conditions. And the bond conditions states as follows: standard bond conditions in County Court at Law number 2. Do you see that type? And it reads as follows: following the return of a criminal information in County Court at Law number 2 of Jefferson County, Texas, all bonds executed for release of any defendant named here are ordered subject to the additional conditions. Number 1, the defendant shall commit no offense against the laws of this state, any other state, or of the United States. Do you understand that condition?
Yes, sir.
Condition number 2, the defendant shall submit to testing for drugs and alcohol. As directed by the court may revoke the bond and order the arrest of any defendant who A, refuses to submit to test for drugs and alcohol, but directed to do so by the court, or B, submit to test for drugs and alcohol, and the test indicates the presence of drugs or alcohol in the defendant's body. Do you understand that condition?
Yes.
Now, condition number 3 and 4 does not apply. However, condition number 5 does apply. And condition number 5 states as follows: defendant is prohibited from possessing a firearm or ammunition unless defendant is a peace officer as defined by section 1.07 of Texas Penal Code, actively engaged in employment as a sworn full-time paid employee of a state agency or political subdivision. Do you understand that condition? Okay. Now, Mr. Johnson, if you violate any one of these conditions, your bond can be revoked. And if your bond is revoked, a warrant will be issued for your arrest, and you'll be arrested and placed in the Jefferson County Jail. Now, the court coordinator is going to reset your case, give you opportunity and time to hire your own attorney. Please have a seat in that first chair. And once she's ready for you, she can ask you to come up to a window. You go up to a window and finish at a window. You'll be free to go, and you have a blessed day.
Yes, sir. Appreciate it.
You're welcome. Let's see. Next case is cause number M330050-1. Case is styled the state of Texas versus Jonica Michelle Benjamin. Jonica Michelle Benjamin was scheduled to be in court this morning for the court's arraignment docket at 9 a.m. At or about 9 a.m., the court bailiff called the name of Jonica Michelle Benjamin at the courthouse door. Jonica Michelle Benjamin did not answer. The time now is 11:35 a.m. on today's date of March 12, 2024. Mr. Bailiff, would you please call the name of Jonica Michelle Benjamin at the courthouse door?
Danica Benjamin. Danica Benjamin. Danica Benjamin. No answer, Your Honor.
Jonica Benjamin name was just called at the courthouse door. Jonica Benjamin, also known as Jonica Michelle Benjamin, did not answer. A reasonable time has passed to give Ms. Benjamin an opportunity to appear in court. State, do you have a motion?
State moves for bond forfeiture.
That motion will be granted. Jonica Benjamin's bond will be forfeited and warrant shall be issued for his arrest. And cause number M330050-1. Next case is cause number 23CCCR2420. Case is styled the state of Texas versus Tychana Simpson. Tychana Simpson was scheduled to be in court this morning at 9 a.m. for courts. Raymond docket at about 9 a.m. The courts to be able to call the name of Tatiana Simpson at the courthouse door. Tatiana Simpson did not answer. Tatiana Simpson has not appeared in court since the court's been in session. The time now is 11:32 a.m. on today's date, March 12th, 2024. Mr. Bailiff, would you please call the name of Tatiana Simpson at the courthouse door?
Tatiana Simpson. Tatiana Simpson. No answer, Your Honor.
Tatiana Simpson's name was just called at the courthouse door. Tatiana Simpson did not answer. Reasonable time has passed to give Tatiana Simpson an opportunity for court. She has not appeared in court. State, do you have a motion?
Statements from board, sir.
That motion will be granted. Next case is clause number 23 CCCR 0810, case of the state of Texas versus Tajana Monet White. Tajana Monet White, scheduled to be in court at 9 a.m. At about 9 a.m., court's going to call the name of Tajana Monet White at the courthouse door. Tajana White did not answer. Tajana White has not appeared in court since the court's been in session. The time now is 11:33 a.m. on, no, 38 a.m. on today's date. Mr. Bailiff, would you please call the name of Tajana White at the courthouse door?
Tajana White. Tajana White. Tajana White. No, Your Honor.
Tajana White's name was just called again at the courthouse door. Tajana White did not answer. Reasonable time has to give Tajana White an opportunity to appear in court. She has not appeared in court. State, do you have a motion?
Statements from board, sir.
Tajana White's bond will be forfeited and a warrant should be issued for arrest in clause number 23 CCCR 0810. And this will conclude the calling of the court's arraignment docket on today's date of March 12, 2024 in County Court at Law number 2, Jefferson County, Texas. Judge Terrence L. Holmes presiding. Everyone, please have a blessed day. State your excuse.
Thank you.
You're welcome.